SJC-13473, Amy Sue Openshaw v. Glenn Romney Openshaw.
Okay. Whenever you're ready, Attorney Owens.
Good morning, Your Honor. Jason Owens, appearing on behalf of Glenn Openshaw, and may it please the court. The case before the court today is dealing with a question that we're calling savings alimony, and whether or not savings alimony should be permitted in Massachusetts. That's sort of the first tranche of the question, and the second part is, even if savings alimony should be permitted in Massachusetts, is it appropriate in this case, given the evidence that was put into trial? Savings alimony, in a nutshell, is that historically, in the lengthy jurisprudence that the state has had with respect to determining the need for alimony, we look at the lifestyle that the parties enjoyed during the marriage. And historically, by exclusion, we can look at our cases talking about lifestyle, and those cases have historically focused on affirmative spending, what people are actually purchasing, the trips they're taking, the vehicles they're buying, things of that nature. When we talk about savings alimony, the question is whether need, that lifestyle, should include savings. So not affirmative spending on flights and stuff that people are buying, but instead on the more passive act of accumulating savings.
Why shouldn't it include savings?
So there's a couple things. So there's been several states that have adopted savings alimony. And when you look at those states, there's important differences between Massachusetts and those states. The main reason that we shouldn't be adopting savings alimony is because our asset division statute, Section 34, specifically takes into account one party's inferior ability to accumulate assets in the future and enables our judges to make a disproportionate division of assets, which are the assets that were actually saved and accumulated during the marriage at the time of the divorce, to account for that party's weaker ability to accumulate assets in the future. When we look at some of the states that have adopted savings alimony, California, Wisconsin, Arizona, these are states that are called community property states, and they have a much narrower conception of the asset division. In those states, community property is assets acquired during the marriage by either party, and it is 50-50 division. And there's very little discretion to deviate from that. So premarital assets is continued separate property. Inherited assets is typically separate property. It's what was acquired during the marriage, 50-50, very little leeway, such that if there is a party that has an inferior ability to accumulate assets, alimony is really their only tool. They look to alimony.
And in those states, because you seem to know them, is that the reason that they allow savings alimony, because their division of assets does not allow them to consider the inferior ability to accumulate assets, as you say?
I don't think that would be fair to say that they define their law in the context of what other states do. I think that...
What is the reasoning that those states use to allow savings alimony?
So the reasoning is that that is the mechanism. Savings alimony is the mechanism to address the problem of one party having the inability to acquire future assets that can't be addressed through the division of assets, not easily.
Can I ask that question in a different way? Of those 14 states, are any of them non-community property states?
Yes. So
Okay.
the three I just listed are community property states: California, Wisconsin, and Arizona. Nearly all of the other states, though, also have an important distinction from Massachusetts, which is they...
So 11.
Yes, I believe with the amicus brief, I saw a new state come down. So, yeah, I believe 11. Well, and so two of those states...
Even I can do that math, so
Yeah.
we get 11. All right.
So two of those states, Florida and Hawaii, do not allow savings alimony. So we have the remaining states that are not community property states or disallow community property. So that is 14 minus 5 equals 9. Those remaining states, I believe all of them exclude what's called separate property, which is that they do not allow for the division of premarital assets or inheritances that come in during the marriage, that the division of marital assets is typically restricted to assets acquired during the marriage, which we don't have in Massachusetts. In Massachusetts, under Section 34.
Our asset allocation is broader than any of these other states, so we don't need savings alimony.
I believe so, Your Honor. I think I say with a little bit of caution when we're talking about 14 states. Is it broader than every single one? There may be an outlier, but it is broader than nearly all of them.
The question, though, is whether under Section 53, this is a permissible consideration when you're looking at the marital lifestyle during the marriage. And one of the cases, I can't remember the name, said something like we shouldn't penalize somebody because they, during the marriage, have acquired stock as opposed to fur coats. And if the marriage, there was an agreement in the marriage to have some sort of frugality, maybe because someone might become a caretaker later on, and that was sort of embedded into the relationship during the marriage, what's the rationale for it not to be included in alimony?
Well, I think there's two ways to answer that. I think you can look at the statutes, and you see under Section 34, one of the factors is one party's inferior ability to accumulate future assets, and the absence of a corresponding factor under Section 53 and the alimony statute. There is overlap between some of those considerations, employability, ability to maintain the marital lifestyle, but the alimony statute, the latter statute, excluded anything having to do with the acquisition of future assets, and in fact, in the income definition for alimony, it actually excludes income derived from assets divided during the divorce. And we have some case law from the Cooper case in 2004 saying that it's inappropriate to enter an alimony order that allows for the accumulation of additional of assets because that should fall under Section 34. So in the hypothetical you're describing, where there's a frugal lifestyle and as a result there's substantial savings, I would argue that Section 34 provides, okay, now we have a larger pot because of that frugality. We have the ability to make a disproportionate division in favor of the party who's not going to be able to do that in the future.
Alimony, I just don't know why, and I want to understand your argument. I think 53 says something like maintain marital lifestyle. If the marital lifestyle is we put this away for whatever reason, one of us might get sick, the kid's education, whatever it might be, and that's what happens during the marriage, why couldn't a probate and family court judge in his or her discretion say, well, I'm going to take this into account as part of alimony?
I think that if, hypothetically, a judge did that without you doing a disproportionate division of assets, then that would start to make sense.
But isn't it allowed under our statute? Because the lifestyle, wouldn't it contemplate basically the peace of mind that married couples sometimes get to put away some money because the washer breaks at the same time the dryer breaks and the car breaks down and, you know, now I've got a little bit of a float because we have the savings. That's part of people's lifestyles, isn't it?
I would respectfully say that a alimony order that allows a party to maintain the affirmative spending, the actual spending, combined with the disproportionate division that puts into that party's hands a surplus of the savings that were actually acquired while they were married.
If we're looking at narrowly alimony in lifestyle, would you agree that that peace of mind that's attendant to savings that couples are routinely do could be considered part of a couple's lifestyle?
I think that in layman's terms, I think that makes sense. I think that the way that the statutes are constructed, we've sort of used Section 34 to address that. But I do think that's it's a jumping off point to this particular case and whether or not, as you say, if we are going to allow savings alimony, perhaps savings alimony is appropriate in concept. Should it happen here? And I think the critical question really in this case is that we have some case law that makes quite clear that when we're determining lifestyle and need, we're to look at the lifestyle the parties lived prior to the separation. In contrast to their post-divorce lifestyles 3 or 4 years later, which could be quite different, they could be spending very differently. In this case, there was a strategy at trial taken by wife's counsel, which was to say explicitly to the judge in the closing argument and also in the evidence presented, that we're asking you not to look at the lifestyle that was enjoyed when the parties were intact. Instead, we want you to look at the wife's current financial statement. So what came in terms of evidence was uncontested evidence that the entire family had spent an average of $165,000 a year over the 3 years prior to the separation.
What do we do with the fact that the husband also outspent the pace of spending that he purported the whole family of 8 spent the prior 3 years?
And that's a good question. I think that you do have to distinguish between the payor and the recipient of alimony. He left his house. He is estranged for his children. He can have what we might call a midlife crisis, buys a sports car, starts spending a lot more. Nevertheless, what he does post-divorce and post-separation is a separate matter from the lifestyle that you're looking at in order to maintain with alimony, which does require you to go back. So what he spends, how they spend their money is they can spend it however they want. So the wife files a financial statement at the time of the divorce, says, I'm currently spending $400,000 a year. That's far greater than what the entire family had been spending. She's allowed to do that. She can spend as much as she wants. Nevertheless, the court's analysis of alimony should be constrained to maintaining the marital lifestyle. Her counsel took the chance that we're going to argue, don't pay attention to the lifestyle during the marriage. We're going to argue, go ahead and focus on the current financial statement. That is not necessarily consistent with the law, but it's not up for appeal, and it was successful. If you exclude the savings alimony, wife still receives $210,000 in alimony from the judge based on her current expenses. And that exceeds the entire family spending during the last 3 years of the marriage. Our issue is that having done that, having waived the examination of the marital lifestyle and said expressly, don't pay attention to that, pay attention to the current spending of the wife, does she get to go back and say, well, while we were married, we were frugal and we had a lot of savings back when we lived this very different lifestyle where we only spent $160,000 a year for a family with 6 children. Now I'm living this new lifestyle.
Just remind me, what was husband's income when he said they were spending $150,000 for a family of 8?
I don't have the exact figure, but it was over $1 million a year.
Okay, so there was a lot of savings going on as a family unit, right?
There, by the process of deduction,
Yes.
you could say, yes, that there were savings going on. But wife chose not to enter any of that testimony at trial because that testimony about the frugality with which they lived ran counter to her main argument, which is that was a very constrained lifestyle. I want you to calculate my current need for alimony based on my new lifestyle at $400,000 a year. That's where the waiver argument comes in. It was an argument where she didn't want that evidence to come in because then they would have had to contend with how frugal it was and how savings was just a component of an otherwise frugal lifestyle. Having done that, does she get to come back and she says, I now have a savings need of $1,000 a week, this round number that I'm tacking on to this very, very different lifestyle today, and without putting in any of the evidence that we see in these other states. Was there a pattern?
The question
of
for us
savings?
is not so much can she do it, but whether it was clearly erroneous or an abuse of discretion for the judge to consider it.
To the extent that we have the Young case telling us that all of the need for alimony should be based on the lifestyle prior to the separation. It's very, very specific. The court's use of the current spending of the wife, when it is twice the spending that the parties engaged in, is in and of itself wildly inconsistent with the standard, and I would argue an abuse of discretion to have calculated it that way. We narrowed in on just the savings component, but it is part of a larger examination in which the judge disregarded the lifestyle during the marriage and simply adopted from the wife's current expenses those that he felt were justifiable without concern for the historical pattern of what they actually did. What she's not doing is saying, I lived a frugal lifestyle then, and there was a savings component in addition to the frugal lifestyle, and together with those two data points of what we spent and what we saved, here's my need for alimony. She didn't do that. She made the argument, disregard all of the lifestyle, focus on the current spending, and then I'm just going to add on that I'd also like to save $52,000 a year based on her current spending. And when you have, as we did in this case, a disproportionate division of assets with a husband where the court has already given her a 55-45 division of assets and a wildly disproportionate division of debts, so that when you look at the net equity in the marital estate, it was 59% to the wife and 41% to the husband. We would argue that that takes care of that question.
Can I ask you just, Chief, if it's okay? Of course. Can you address briefly the allocation of assets after paying down the debt?
So the court has broad discretion to order a disproportionate division of assets for the basis that they did here. In fact, the court said specifically in the rationale, especially because of her inadequate ability to earn assets in the future, we're going to make a 55-45 division of assets, and that's what they did. What he then did was he did a division of the marital liabilities where there was approximately $300,000 in the husband's name in the form of federal tax debt from the last 2 years, compared to $5,000 in credit card debt in the wife's name. And the court said, with the division of liabilities, I'm going to assign each of you what's in your names.
Maybe I just misread it because the tax, he filed personally?
Yeah, the wife filed individually.
Okay.
And the court said, that's okay, she doesn't have to file jointly.
But I guess the penalty for him filing individually was he owned the debt.
He owned the debt, and certainly, that was saved up and it was divided and it was income. So, the question there is whether or not the judge who made the findings supporting a 55-45 division of assets, but made no such findings about the liabilities, just simply said, I find it's equitable to do it this way. Well, that moves the needle. It ends up being a 59-41 overall division.
Is that a discretionary call by him?
I think that it's a discretionary call, but it still falls within the factors under Section 34. And if all of your factors that you describe, the findings that you make, are all focused on 55-45, then you need to probably make some additional factors when you're going to do something very different on the liabilities.
Chief, can I ask one more question?
Yep.
Thank you. So he doesn't say 55-45. He says approximately, and that is the response that's given by the wife in her brief. Can you address that? Because it's not like the other cases that you cite where the judge says it should be this and then it ends up being different. Here, how approximately close to 55-45 is 59-41?
Okay, so the division of assets in the judgment was split pretty carefully 55-45.
Right, it's the division of debts that
Right.
results in the 60-40 split.
Right, and so that's just a matter of essentially taking $4.7 million in assets and then acknowledging that there is a little over $300,000 in debt, of which 95% of that is going to come out of the husband's share, bringing his share down, while really not moving
So I
the wife's.
understand the math, and you're running out of time, so my question is about approximately. He doesn't say, I want to absolutely do 55-45. He says approximately. And is 60-40 close enough?
And I think that I would answer that it's not close enough. That's essentially doubling the disproportionality. I mean, it's coming very close. You've supported a 5% difference from a 50-50 division. Going up to 9% is a very substantial jump without any additional findings. And I would also say that I think that if the court were to say that savings alimony is unsupported because of the disproportionate division of liabilities and not just assets, I think my client would waive, his position on the disproportionate division of debts. He would say, okay.
Not surprisingly.
But if the court's going to say savings alimony stays in place and there's a remand, you would reserve the right to also argue the liabilities issue. If there's no further questions, sure. Thank
Okay,
you.
Thank you. Attorney Spencer.
Good morning, Your Honors. May it please the Court. Sean Spencer for the appellee, Amy Openshaw. I'd like to start with a discussion of the term need in our alimony statute because it's important. There's a connotation you could read into the word need that involves necessity, bare minimum, some sort of evaluation of the marital lifestyle. And that is not the law of the
But
Commonwealth.
need in young versus young is somewhat focused and arguably narrow.
So the question on need, Your Honor, in all of our cases, including young, is what's the cost today to meet the shortfall between the wife's current income, post-divorce, and the marital lifestyle, maintain that marital lifestyle today? And that goes to actually the evidentiary question that's raised in my brother's argument. Not only is it appropriate to consider the evidence that the wife submitted about what her current lifestyle cost, it could be error to not consider that cost if the test is what's necessary to maintain the recipient spouse in the marital lifestyle today. If I look back to what I was spending 4 years ago on gas and groceries, I can't do that today. There are all sorts of reasons. Every case is unique. There are lots of justifications in a given case to look at what's at the time of the divorce.
But,
what's
one
necessary.
of the problems I have with the judge's findings is that he doesn't address the husband's statements as to what the family of 8 spent for the prior 3 years before the separation.
Well, I think the judge blows past it because it's so much out of proportion with what the parties are doing now.
But how do I know that? I know that's what you think and what you state in your brief, but what's the basis for that?
Well, number one, it's within the trial judge's discretion. Number two, it's apparent from his findings. He doesn't say, I'm going to award future costs regardless of need. In 2 separate portions of the findings and rationale, the judge refers specifically to the cost to maintain the wife in the marital lifestyle. So Judge Boyle is very much focused on the standard that this court has articulated. It's
Do
not-
you think because he focused on the current spend of the wife, necessarily he disbelieved the husband's allegations as to their 3 years prior to separation spend?
That's correct. And I think that to hold otherwise would open the door for a flood of appeals challenging failure to connect every single dot in the opinion.
No, but this one's an important dot.
And I think
There's
it's
some
connect-
balls you can drop, but this one is important to determine the lifestyle, the pre-divorce lifestyle.
Understood. We know what the judge relied on.
Could he rely on the 2020 or 2020 financial statement?
I mean, that statement's out of date by the time we get to 2021. But I think he relied on the most recent financial statement. And in fact, you see in the findings that he went through that with a fine-tooth comb. He looked at what the spending was. He struck several items, struck more than several items, I believe, and then added a few that would be caused as a result of the order he was entering. I think this was a careful decision by the trial judge. I'd like to turn to the question of whether savings is part of the marital lifestyle. I would urge the court not to create a carve-out from the marital lifestyle for 3 reasons. First, it would create an alimony shelter. It would allow for manipulation of financial affairs to shelter potentially decades of future income from the alimony determination. Second, it would compound the economic injustice suffered by spouses who have spent years out of the workforce as full-time caregivers. And third, it would rest upon what I think is just an incoherent distinction between 2 different types of financial allocations by the parties. And let me start with the last one. As I'm thinking about how you could write the opinion in this case to find for the husband. So there would have to be something different about savings. And I came up with 2 possibilities, and I think neither one works. So maybe savings are different because they create value, which ultimately gets equitably divided. That's the case for lots of the things that this court has already very explicitly referenced as part of the lifestyle. Acquiring vacation homes, acquiring expensive vehicles. All those things build value and are divided. The fact that happens doesn't remove them from the lifestyle the parties lived. So another possibility would be the savings have only an intangible benefit, not some tangible benefit to the parties. And I think that fails for two reasons. Number one, savings, in fact, I mean, yes, they create a feeling of security for me, but that security is against calamities that might come to pass. I run out of funds in retirement. I or a relative, a parent, gets sick and I need to care for them. When those calamities come to pass, even if it's just the washing machine and another appliance breaking at the same time, now the benefit's tangible, just as tangible as if it's a car I was driving during the marriage. And there are plenty of items that are traditional consumption spending that this court's already talked about as being within the marital lifestyle that only have intangible benefit. If I buy precious artwork and display it on my walls, I don't use it, I don't wear it, I don't engage with it. I enjoy it. I enjoy that I see it. I enjoy that others see me having it on my walls. Those benefits are intangible. So tangibility can't be a coherent dividing line.
What about the fact that Section 34 specifically includes, I forget, the inferior ability to accumulate assets in the future, and Section 53 does not? Or whatever the alimony statute is, sorry.
Well, but what it does include is the marital lifestyle. I don't
so
think
you
that,
think the statement in one doesn't preclude its inclusion in the other because of the marital lifestyle
yes, for sure.
language?
For sure.
Is charity different?
Thank you for bringing that up. I forgot to mention it at the start. Charity is not at all different. And I'd point out, first of all, charity is not disputed in this case. The charitable contributions, the record is clear, were simply the parties tithing as part of their religious observation. No one disputes that it was happening or the amounts, and it's not been raised on appeal. I don't think it's any different from savings. I certainly don't think it should be something that's carved out. I think that's just not, it's not a good look for a rule that this court could adopt, saying that we're gonna value consumption spending, conspicuous consumption, but we're not gonna value prudent savings or contributions to charity. If those are part of the way that the parties before the judge lived, those are fair to include.
Can I ask you about debt and why it was not erroneous to saddle the husband with essentially 99% of the debt?
Well, because it's well within the trial judge's discretion to not make an equal distribution. And it's clear that there's no mistake.
But his aim was to get close to 55-45.
His aim was approximately 55-45, but it's not a case like the home equity line of credit case where there's just a massive mistake. There's a $90,000 swing in what the trial judge said was to be a precise 50-50 split. Here we know exactly what the trial judge was doing. There were 4 very specific ways to implement the 50-50 split. It surely didn't escape Judge Boyle's notice that the math didn't come out to exactly 55-45, the approximately 55-45.
But there's no explanation other than everybody takes their own debt in that paragraph in his findings. And I'm struggling with why husband should take 99% of the debt. Other than it's in his name for the family income taxes that he filed.
Sure, one possibility is cash flow, and that would be a reasonable consideration for the trial judge. But I also don't know that it's Judge Boyle's burden to put that explicit explanation in the findings when if he said 45-55, 55-45, or 59-41, all of those are within his discretion. I think the question on that point, Your Honor, is whether Judge Boyle made a demonstrable mistake and whether that mistake was big enough to justify reversal. There have been cases where, I think one of them was an attempt at 50-50 and it came out to be 47% to the wife. And that was not reversible error. Mathematical precision is not required.
What about Pellant's argument that the wife's spending is just so much more now, and that this really isn't about lifestyle during the marriage, but it's more about, not his word, but profligate spending enabled by an additional $1,000.
Yeah, I don't think that Judge Boyle credited that all of the expenses that husband put together and claimed were all that they spent during the marriage was accurate. I don't think Judge Boyle found that to be the case. And I do think it's important to point out that I wasn't trial counsel, but I know from reading the transcript, trial counsel did not accept those chalks that came in and that were put forward in the trial as proof of exactly what was spent. The section that my brother's brief refers to, if you go back and read it, trial counsel is referring to those dismissively and is pointing to the cost today as what Judge Boyle should rely upon. What the wife's lifestyle, which is similar to what she lived in before, the house she lived in before, there's not some change to what the parties are doing. The cost today is what has to be the standard. I do also want to point out what evidence there was of savings in the record, because I think that's important. The wife is clear, and this is at page 408 and 414 of the transcript. She's clear that this was a monthly practice. This happened each month. And the husband's testimony, even if you didn't have to rely solely on the wife's, the husband's testimony is that he would look out a month or two or three, see what expenses were coming, and move funds that were available to investments. The parties agree there was savings in this case.
What's the support, though, for the number?
The only support in the evidence is the wife's submission of financial statements, which came into evidence of $1,000 a week. Now, if you look back through the transcript, husband's trial counsel never cross-examines about that amount, although he cross-examines about other aspects of the statement. And I'd suggest one possibility is the reality that it was much more than that. I mean, this is a huge income, an accumulation of a really significant estate. My submission is that's probably an undercounting by the wife of what happened during the marriage, although that's certainly not, I'm not raising an issue on appeal on that point. If the court has nothing further, I rest on my brief.